Those who don't know, I'm Stephen Greenwald, President Emeritus of the American Association of Jewish Lawyers and Jurists. I welcome you and I welcome our speakers who I will be introducing. We will be introducing shortly. The idea for this this program really came from my discussions with Hernan, who hopefully will join us shortly, who's the president of the Argentinian Association of Jewish Lawyers, that it would be an interesting exercise and enlightening, hopefully, to compare the judiciary. Our focus, of course, is on the judiciary under three different constitutional or quasi-constitutional regimes. And that's the US regime, Argentina, and Israel. So, and our focus will be on, as I said, on the constitutional structure in each of the three countries from the standpoint of separation of powers, the independence and power of the judiciary vis-a-vis the other branches, the method of selection of justices, the High Court's power to overturn legislation based on the Constitution, or in Israel's case, a partial constitution, as we'll hear, and the right, if any, for the legislature to override a High Court decision. And there is a way to override a High Court decision, even in the United States, and I'll leave Abner to explain what that is. So again, we thank you for agreeing to participate. And I know that I thought Hernan was on, but in the meantime, Daniel Reisner, who is the chief counsel for the IJL, which is a co-sponsor, and I should have mentioned all the co-sponsors, forgive me if I didn't, but they're listed on the notice you got. Daniel is a great friend of ours and chief counsel for the IJL, and he will make a few introductory remarks before we turn to the speakers.
Thank you very much, Stephen, and good evening to everyone. It's a pleasure being here today, and thank you for both the AAJL and the Argentina JL for coming up with this important collaboration, which is especially important these days.
Yes.
These are difficult days in Israel. They're difficult for Israelis, they're difficult for the country. They're difficult for Jews all over the world, and they're difficult for all of our friends all over the world. They're difficult because we are currently struggling to find balance in a variety of fields which we did not have before. I promised Stephen that this would be a very short comment, so I would just say two quick points. One of the founders of the International Association, which led to all the other associations we have here on this call, was the famed French, I struggled to find one word to describe him, so great person, René Cassin. And René Cassin was also a jurist, but was so many other things, a humanist, a philosopher. He received the Nobel Peace Prize for his role in drafting the Universal Declaration of Human Rights in 1948. And there are two things I would take from René Cassin for this discussion tonight. The first, on the tactical level, is that Article 8 of the Universal Declaration says that everyone has the right to an effective remedy by the competent national tribunals for acts violating the fundamental rights granted by constitution or by law. So at the tactical level, one of the discussions going on in Israel right now is that there is a growing concern that some of the changes the government is proposing will impact or even harm the application of this principle in Israel. We don't know if that's true or not, but the potential is there. And I'm sure that Professor Navot, who I've known for many years, will speak about this in more depth. But probably the more important part of René Cassin's legacy to our discussion today, René Cassin believed that being Jewish and promoting international human rights were both complementary principles. And in fact, all of his activities post-World War II were focused on finding a way to join these two principles. And that is what our organizations are obligated to do. So because we do not want to repeat the mistakes of others, and we want to learn from the mistakes and successes of others, this evening is so important, because this is an opportunity for us to learn what has worked and what has not worked in other countries facing similar dilemmas. And for that, I thank everyone for organizing this important evening, and I wish all an informative event and hopefully a beneficial one for the practical issues ahead of us. Thank you all.
Thank you. Thank you so much. And Hernan is here, so if you could say a few words. Thank you, Hernan.
Very much, Alisa. Thank you, Daniel. Thank you very much, Steve. Couples of months ago, we sat on a table with Steve and we started talking about how we can
The Upper West Side.
together. How can we do something together, both organizations, and now we are here, more than 100 people, 150 people that were registered in this seminar. They are getting in slowly, but we are almost 80 people here in around the world. So I'm very proud of what our two organizations under the umbrella of the international organization is doing. So as I said, I'm very, very happy. I'm also very happy because we have so important sponsors in this seminar. Well, we have the TEDx DC, JCR, obviously the international, but in Argentina, the Net of Justice for Women, the DAIA, which is our central organization with AMIA as well, but the DAIA is the Federation of Jewish organization of all the Argentina. More than 60 Jewish organizations are under the DAIA, and our most important lawyer bar association, which is the Colegio Público of Abogados of the City of Buenos Aires as well, is sponsoring our seminar. Then I would like to speak a little bit, just 1 minute, about the Argentinian Association of Jewish Lawyers, which our Marcos Gravivker is a member. He is the vice president of the International Association as well. But our organization aims to promote professional development, legal education, and networking opportunities among Jewish lawyers in Argentina. In addition to this, we strive to advance legal and social justice issues affecting the Jewish community, including combating anti-Semitism, supporting Israel, and advocating for the recognition of Jewish traditions and customs in our legal system. As a civil society organization, we obviously operate independently from the government, and we have specific social, political, and cultural objectives. But mainly, we believe in a Jewish concept, which is Tikkun Olam, as a guiding principle, which represents our powerful call to action for individuals to work toward creating a more just and equitable society. We firmly believe that a stronger democracy and the respect of the human right is the key to repairing the world. The Argentinian society, the Argentine Association of Jewish Lawyers, is committed to promote social justice, human rights, and equality, which are essential components of a healthy democracy. We will continue to work tirelessly toward creating a more just and equitable society, and we really believe this kind of meetings, this kind of seminar goes toward this goal. So I want to thank you, Steve. I want to thank Alisa. I want to thank Agustin for working so hard about this seminar, and of course, all the members of our organization that helped that this day is a very proudly day for all of us. Thank you very much.
Thank you. Okay, well, let's get the program started. And at this point, I'd like to introduce Professor Abner Green from Fordham University School of Law. Abner's, if you've looked at the flyer, you've seen that Abner is more than highly qualified to discuss the topics we want to talk about today, having clerked for Justice John Paul Stevens in the United States Supreme Court, and is truly an expert in the American Constitution. And I thank him for joining us today. So, Abner.
Thanks, Steve. Thanks to all of you, to the organizations. I'll just jump right in, if that's okay. Steve asked me to address certain questions, which he outlined to you at the beginning. And so I'll start with the sort of basic structure of government in the US, and then talk more specifically about the judiciary and some of the questions there. I just don't know how many of you already know this cold and how many don't, so I'm going to do all of it. The basic structure in the US is Article 1 of the Constitution establishes the legislative power, all of which is vested in Congress. Article 2 establishes the executive power, which is vested in a president of the United States. And Article 3 is the judicial power, which is vested in a Supreme Court, which must exist, and lower federal courts, which may exist or may not exist at the discretion of Congress. That's an interesting fact. The Congress, which makes the laws, is bicameral. There is a House of Representatives that is proportional by population. And there is a United States Senate, which have 2 senators per state, regardless of population. So it is severely malapportioned. The largest state, California, gets 2 senators, and the smallest state, Wyoming, gets 2 senators. This was one of the great compromises of the original convention. The small states would not have joined in unless they were getting the same number of senators as the large states. It is, in the view of many of us, one of the several severely anti-democratic provisions in the Constitution. There are others. The president, and there are, so it's 2-year terms for the House, 6-year terms for the Senate, and there are no term limits for either. The president, according to an amendment that was ratified in the 1950s, now has term limit of 2 terms, and they are 4-year terms. This was after Franklin Delano Roosevelt was elected 4 times, and there was enough of a backlash to that, that the Constitution was amended to make it a limit of 2 4-year terms for the president. President is elected nationally according to a very bizarre system called the Electoral College, which I can explain if people want during the Q&A. It's another anti-democratic part of our systems. There are several of them. Members of Congress may not be removed, generally speaking, except during elections. There is a provision for Congress to expel members of Congress that has happened very rarely. The president, in addition to being removed from not being reelected, may be impeached and convicted by the Congress and removed from office. This has never happened. I can say more about that if you want. Federal judges have so-called life tenure. There are 2 provisions in the Constitution that essentially gives federal judges life tenure, and also protection against salary reduction. Their salary may not be reduced from after they join the courts. Judges may be impeached and convicted and removed, and there have been some of these, all I think, in instances of having committed criminal activity. Now, as for the federal powers, let me just say a little bit about this. Even though we talk about it as separation of powers, there are importantly blended powers. Most importantly, the lawmaking power. A bill must pass both houses of Congress, and the president must sign it to become law. If the president vetoes or fails to sign the bill, then the 2 House and Senate may override that veto by 2/3 vote in each House. Also, treaties are made by the president with the consent of the Senate, and judicial and other appointments, key appointments, are made by the president with the consent of the Senate. The other main point I want to make about separation of powers, before I say more specifically about the judiciary, is there's an important provision of our Constitution. I have a copy of it right here. If any of you have it in front of you or have it online, you could look this up. You could all look it up online. It is Article 1, Section 6, Clause 2. Article 1, Section 6, Clause 2. And this is referred to, there are two parts of it, but this one is referred to as the incompatibility clause. And it reads, no person holding any office under the United States shall be a member of either house, meaning the House or Senate, during his continuation in office. So this is the key provision that makes us not a parliamentary system. If you are a member of Congress, of the House and the Senate, you may not also be a member of the executive branch. You may not be the president, you may not be the vice president, you may not be running any of the cabinet or executive departments. Those are strictly separated per that provision of the Constitution. It's important to know that. So I talked about how federal judges have so-called independence from life tenure and protection against salary reduction. Federal judges from the beginning have also had the power of judicial review, which is the power to declare unconstitutional actions of either the executive or the legislative branches of either the federal government or the states. This power is not explicit in the Constitution. That strikes many people as odd. There's no specific sentence that says what I just said. But there are many arguments in its favor, including historical ones, that the framers understood that the Supreme Court and the other federal courts would have this power of judicial review. And that has not really been much questioned. It's a little bit questioned, but it's not much questioned. Now, the debate about this power of judicial review is, I would say, of two sorts. One is how vigorous should it be? To what extent should the Supreme Court give any deference to either the president or Congress, or should the review always be de novo with no deference? And that is vigorously debated, and your view on this might depend on what part of the Constitution you're interpreting. For example, some people think there should be more vigorous review for freedom of speech, freedom of religion, freedom of the press, but less vigorous review for so-called separation of powers problems, that more of that should be left to the political branches. The other big debate, which I'm sure you've all heard about and have in your own countries, is the debate over the proper methods of constitutional interpretation. For those who are eclectic, and I count myself as an eclecticist, you look at everything you can get your hands on. You look at the text, you look at the structure, you look at precedent, you look at original meaning, you look at history, and you look at what I would call applied political theory to the place. That is, in our case, the US. As you may know, the United States Supreme Court over the last few generations has increasingly engaged in what they call originalist interpretation, where they seek to determine the original meaning of a constitutional provision, which would either be 1787 for the Constitution, 1791 for the first 10 items of the Bill of Rights, and then right after the Civil War in the 1860s for the important 13th, 14th, and 15th Amendments. I'm happy to talk more during the Q&A about this. I am not a fan of original meaning. I think it is relevant, but should not be binding. But there's heavily debated.
Yes.
The Congress has no power to overturn the Supreme Court's interpretation of the Constitution. The court sometimes overrules its own precedent, but apart from that, the only way to change the Supreme Court ruling on the Constitution is to use Article 5 of the Constitution. Article 5 of the Constitution, which is one paragraph, is the rules for how to amend the Constitution, and it is very hard. You basically need 2/3 of the House and the Senate to say yes. Then the amendment goes to all of the 50 states, and then you need 3/4 of the 50 states to approve the amendment. So we have had 27 amendments approved since the beginning of the United States. Very difficult to do. The last thing I wanted to say, and then I'll be done, is federal judges are, as I said, are selected by the president, and then the Senate has to confirm them by a majority vote. There are hearings before the Senate Judiciary Committee to give the senators a chance to question the nominees. Even for the Supreme Court, which are very highly publicized and televised, these hearings have become a charade in the sense that there is no serious discussion of the candidate's jurisprudence. The candidates all feel that if they discussed their jurisprudence in too great detail, they might lose some votes. And they figure that the president, having named them and having done their job whipping the senators, as we say, will have produced enough votes to get them through. So there's all sorts of interesting questions that they get asked that they figure out ways of not answering. And that's been true for both Democratic and Republican nominees. The only way for that to change would be for the Senate to refuse to confirm nominees unless they answered more questions. I think that is it for my introduction. I'm happy to answer questions later.
Thank you. Thank you so much, Abner. And there will be many questions, I think, I expect. But I think the best thing to do is to move on with our speakers, and then we'll address the questions that are being asked. I move now to our second speaker, Claudia. Claudia, you.
Yes. Let
Bueno.
me extend Claudia 1 minute. Claudia
Yes.
is going to speak in Spanish, but Oriela is the interpretation. She's doing the translation of Claudia in English. So if you check below, there is a part that you say.
So we can see.
Introduction, yeah.
We'll be able to see
Below.
the translation.
Yeah, translation, and you put in English, and Oriela is going to be the one that is speaking in English, but Claudia is saying in Spanish.
All right, Claudia was a judge in the Federal Appeals Court in Argentina now, and a scholar of constitutional law in Argentina. We look forward to your insights and your comments, so welcome.
Thank you, thank you. Bueno, buenas tardes. Estoy muy agradecida a las entidades
Hello,
organizadoras.
everyone. I'm very thankful for being here talking to you.
¿Se ve bien la traducción? The translation is okay?
No, I don't see any translation, but
Let's see.
oh, Abner says okay, you can click to English.
There is an interpretation button and you have to click it to English to have it
Oh,
available.
It's on the bottom of your screens.
mhm.
And it's next to, you should have a participants share screen. And then there's a language button. So let's hope we're gonna try our best, but thank you, Claudia, and to Ariella.
Thank you, Alisa.
Uh,
Well,
Go ahead.
para comenzar,
To start,
Argentina
Argentine constitution is a written text
se remonta históricamente a 1853 y 1860.
that has been written in 1953 and 1960. Is a brief text. It only has 130 articles, sections. It has another kind of structure, but it's brief. The system is a representative and Republican and federal system. Those are the three basic concepts of this Argentine system. And these are distributed, the powers are distributed, similar to the US Constitution, in three main powers. The Congress with two chambers, the President of the nation, and a judicial power. there is another body, which are the prosecutors and the public defenders, which has another name, and they have autonomy with respect to the judicial power and the other two powers. The Argentine system is basically a presidential system. And as it was explained by Abner, it has clauses to avoid that a legislator can perform tasks in the executive branch, or it's not similar to a parliamentary system as the one from Israel. Generally speaking, there is a common ground that the inspiration of our structure, constitutional structure, is based on the US Constitution. That is why what was explained by Abner is applied to Argentina on a 90%. Here we have some differences. I want to make a comment about how the judges are appointed. There are two big groups. The judges from the Supreme Court, which is the same process as United States. The president will designate a candidate and the Senate will agree or not on that. Till 1994, the tenure was for life until they decide to retire. But in 1994, there was a constitutional clause that provided a limit on the age. The limit was for 75 years old. And that applies to all judges, also to the judges from the lower courts. For those judges from lower courts in 1994, it was also added a new body that was based on an European body. This is the Council of the Judiciary. Okay, this body has faculties to help in the appointment of judges of these lower court judges. It's not for the judges of the Supreme Court. In order to select a judge from the lower courts, this council will decide. They will make a list of 3 names. The president will choose one of those candidates, only one, and the Senate will agree on that. So here we have an additional step that was added to the process. I want to say that also in order to remove a judge from the court, we have to submit a petition to the House of Representatives, and then the impeachment is carried out by the Senate of the Argentine Republic. For lower court judges, the presentation is made by the Council of the Judiciary, and the impeachment process is done by another body that appeared after the constitutional reform in 1992, okay, which is a jury for the impeachment. I also want to mention 2 institutions from our constitution that are from Argentina, and that will complete the balance that comes from the checks and balances system. In Spanish, we have several ways of saying this: the checks and balances, the balance of the different powers. These institutions are historical. They come from crises and tragic moments of the Argentine history. One comes from the Section 39 that prohibits that Congress will give somebody the total power, because that will break the balance between those powers. And that has happened, unfortunately, whenever we had violations of human rights. So this is an issue that has been put in our constitutional text. The other one is Section 109, which specifically prohibits the president of Argentina to intervene in judicial cases. That person is prohibited from having functions in the judicial powers, or even if there is a closed case, that he can open that. So he has all of these prohibitions in order to reinforce the independence of the three powers, okay, and the equilibrium that we need from them. When we are in Q&A, I can also give more information about this. Now, with respect to the Supreme Court, the court has 160 years, and it is defined as the head of one of the powers of the state. It can do what you call the judicial review, which in Spanish is said as the constitutional review. Okay, it's the same with another name. And the court performs this function as a final and definitive function. Okay, so nobody could provide another solution or interpretation regarding that case. Also, it's very important the international dimension of the treaties, the international treaties that also make the convention's controls, because Argentina has ratified several international treaties and also has presence in the Inter-American system for the protection of human rights. For the Argentinian Supreme Court, a sentence that does not respect those standards from that Inter-American court is arbitrary. Now, I would like to provide some examples so you can see the dynamic that shows how the court's opinion is the last words, the last opinions regarding a dispute, okay, or a controversy. There is no case such as the Dickerson case for the US Supreme Court that provides clear standards, but that is why I want to provide these examples. In the constitutional reforms of 1994, one section was added so that the destitutions of lower court judges cannot be reviewed. The Constitutional Convention said that they wanted to change the criteria of the court in a case called Nicosa, which allowed the revision of a destitution. However, in 2013, in the case Brusa, the court said that it maintains the faculty of reviewing cases, and that is compatible with the new section of the Constitution. Maybe the Constitutional Convention didn't understand what the court said, and so the court has the last word when it comes to reviewing cases. It's not for the content of the decision, but yes, regarding the due process. Okay, another example. The reform in 1994 provided a limit regarding the tenure of the judges. Okay, the limit was of 65 years. The court in 1994 said that that was null and void. Then I can explain the motives and reasons for that, which were based on the fact that they did that without respecting a certain process. That provided a new dynamic for the discussion. There was a lot of critics and opinions from both sides. And in 2017, in the case Schifri, the court changed its own criteria and affirmed that constitutional reform was valid. And then this age limit was accepted. Now I want to provide two examples regarding the National Congress. Congress enacted a law related to the criminal code that says that having certain drugs for personal consumption in small quantities is a crime, and that the person that performs that crime should receive a penalty, okay, and prison. This is a very long story of how this evolved, but I want to stop here because in 2009, in a case called Arriola, the court says that that was unconstitutional. That solution is still up to this day, and Congress has not made any attempt to make public hearings or talk to experts or design a special commission. And so in some way, it accepted that criteria. And the other example is from the case Muña, which is very interesting and contemporary. There is a criminal law that establishes how much the sentence can take for those persons who make crimes against humanity. Okay, for these crimes against humanity. At the beginning, in May of 2017, the court said that with a majority, a beneficial mechanism was applied which will reduce the sentence, even when we have crimes against humanity. 9 days later, the Argentine Congress enacted a law that changed that criteria and saying that if it was a crime against humanity, then we cannot use that benefit, okay, in order to make that commutation of sentences. So that was what the minority of the court thought. This was what happened in the case Ledbetter against Gutierrez in the United States. And then in 2008, two judges from the Supreme Court changed the meaning of their votes. They applied the new law. So now a new majority was created that interpret in the same way as the Congress did, which is not to allow this benefit in cases like this, which are very severe. With this, what I want to share with you is that there has been a dynamic based on history, and there has been many changes and situations regarding checks and balances and that system. And I want to quote Carmen Argibay. She said that we had to be very careful and very prudent and when regulating the balance between the people sovereignty that is expressed through political bodies and the sovereignty that come from the constitutional values, because there has to be a judicial power healthy and with complete faculties given by the Constitution in order to avoid that maybe the decisions from the majorities will agree the minorities. And to close, the Inter-American system always established, for example, that the pardons for crimes against humanity were null and void, okay, that were against the Treaty of San Jose de Costa Rica. So sometimes the work of the representatives that were chosen by the people has to be related to the judicial activity that will provide a balance between the constitutional balances in order to avoid the damages and injuries to the human rights, which is very important. And I want to talk about the Inter-American Charter that Argentina signed 21 years ago. In order to have a democracy, we need the division of power, we need check and balances, and the defense of the treaties and conventions that protect and safeguard human rights. Thank you very much.
Thank you. Back to English.
Thank you. And thank you so much to our translator, Oriela.
Yes, thank you. Or who was it who did it, Alyssa?
Oriela Bruno.
Okay, thank you. That was really beautifully done. Thank you so much.
It
And
definitely
Claudia.
was, yes. All right, so now we will turn to Susie Novote, Professor Novote. Tell us about the constitutional system in Israel.
Okay.
Now or tomorrow. So we are all aware of what's happening and the dynamic that's going on. And
I'll try to. First of all, thank you very much for this invitation. It's a pleasure to be here with you. Muchas gracias, un placer, Claudia, Agustín y todos los sudamericanos por ahí. I will turn to English so you don't have to make this translation. Let me give you a brief overview on the constitutional structure of Israel. Israel, unlike the United States and Argentina, has no one document known as the Constitution, but it has a series of basic laws that have been granted constitutional status by the Supreme Court. Now, in 1948, when Israel was established, the Declaration of Independence said that the Constitution would be adopted by the Constituent Assembly. And the Constituent Assembly was indeed elected, both as the constituent power and as the legislative power. They had long debates on the future constitution, but they reached a deadlock. And therefore, they decided something that is very common in Israel. They decided not to decide, meaning that they decided to endorse a compromise according to which Israel would introduce a constitution in stages. What is the constitution in stages? Imagine that you have a salami and then you cut it into tranches. So each chapter of the constitution would be a piece of or tranche of this salami. We will have a constitution in stages. Each of the chapter would be branded or named a basic law. And at the end, nobody actually told us when would be the end. They thought about perhaps 1 year, 2 years, 3 years, but we are in the 75th years of Israel and still it's not finished. So this is our, well, I think, perhaps limited constitution. Now, until the early 1990s in Israel, the Knesset actually completed, the Knesset is the Israeli parliament, completed the enactment of almost all the basic laws, all the chapters of the constitution dealing with the institutions. We have the government, we have the Knesset, we have the judiciary, the president, we have, of course, one chapter on the army, this is Israel, and so on. But still missing were two basic laws. And if we would have enacted in the 1990s 2 chapters more, the constitution would have been complete. What are the missing chapters? The first one is the basic law on the legislative, or basic law on legislation, that would actually regulate the legislative proceedings for enacting laws and basic laws, and would, of course, state that the status of the basic laws are a constitutional status. And what else is missing? A chapter on human rights was also missing, because a basic law dealing with human rights was very controversial in the Knesset and in Israel. There's no agreement on several, I think, problematic issues and problematic rights in Israel. So in 1992, another compromise, or political compromise, was reached in order to go forward with the basic laws on human rights. And they took the basic law on human rights and divided, they took this piece of the salami and they divided into small pieces, meaning that instead of having one basic law dealing with human rights, they left outside, leaving pending the problematic rights, which of course are equality and freedom of speech and freedom of religion. And they decided to enact 2 basic laws dealing with human rights that are not controversial. First of all, the basic law on human dignity and liberty. And I think that nobody actually understood what human dignity or liberty means. They know what equality means, but dignity, it was, very amorphous. And basic law on freedom of occupation. And freedom of occupation doesn't mean occupation on the territories. It means freedom of occupation, professional occupation, meaning the right to choose your own profession. And what is interesting in these 2 basic laws, that they included what we call a limitation clause that is similar to the one found in the Canadian Charter of Rights and Freedom. And according to this clause, according to this limitation clause, a law that infringes upon one of the human rights in this basic laws will be valid only if it was enacted for a proper purpose and proportional, meaning that the limitation is not greater than required. So these basic laws actually limited the power of the legislative of the Knesset. And these basic laws were followed by a monumental decision in Israel, handed down in 1995, in which the Supreme Court declared that the court has the power to enforce these limitations on human rights on the legislative branch, and therefore it has the power for judicial review of laws, even if that power is not explicitly mentioned in the basic laws, exactly as Abner stated as to the United States. And of course, the basic, I think the ideology in this monumental decision was, of course, Marbury versus Madison, meaning that if the Americans could do that, then we can do also the same. So what does it mean, this idea? That Israel has no document known as the Constitution. It has several basic laws, but the problem is that they are very, very easy to enact and very easy to amend. It is not a real constitution, because the government, of course, may change these laws using the Knesset very, very easily. Okay, it is a constitution in one meaning. It means that if a law infringes today, and I say today, not tomorrow, Steve, because I don't know what's going to be tomorrow in Israel, but today, if a regular law infringes upon my rights that are protected in one of these basic laws, then I would go to the Supreme Court, sitting as the High Court of Justice, and the Supreme Court will effectively protect me and will strike down the law and declare it unconstitutional. Now, what is the problem with that? That this is a fragile constitution, and it exposes Israel to the dangers that we are seeing today in many countries, the dangers of democratic erosion. And it exposes Israel to this danger much more than in any other democratic country, because in every country, and we just heard it, there are mechanisms, there are tools that decentralize political power. You have checks and balances. We just heard it from Abner and, of course, from Claudia. You have a rigid constitution protecting human rights or protecting the rules of the game. You have the splitting of the legislative authority, both in the United States and in Argentina, into two houses. You have the right of veto given to the president on legislation. You have a federal structure. And you have both countries that we just heard. You have well, not the United States, I said Claudia, and of course, Argentina, and of course, Europe. You have international organizations and courts, like the European Court of Human Rights or La Corte Interamericana. So all these tools are part of the idea of checks and balances, but none of them exist in Israel. None of them. Israel is unique. Is the only country among countries that are defined free by the Freedom House that does not have any tool for decentralization of political power. And what does it mean? It means that our parliament has 100 members, and 61 members out of 100 is all you need to change Israel's basic law. 61 is all you need to change the power of the court, to make the president poof, disappear, like in Aladdin, you know, the cloud in Aladdin, disappear, or to delete any human right. 61 in Israel means absolute power. And the Supreme Court today is the only branch that may limit this absolute power. Because in Israel, okay, the government has almost all the power, not like we just heard, because we are a parliamentary system. And in Israel, the government controls the parliament by coalition majority and by coalition discipline. So we have only one branch that can limit absolute power. And actually, I would gladly take Claudia's article that no one should take absolute power like we just heard, but we don't have it. And therefore, because the Supreme Court is the only one, therefore nowadays the Supreme Court and its independence are under attack. Now, something about the judiciary and the selection of justices, which is also, I think, interesting. Israel has a very professional, independent, and I would also say world-known judiciary. Judges are not elected, they do not answer to the people the way the members of the legislature do. And the judges' independence is mainly guaranteed by the way they're appointed and promoted, not by the salary, by the way. Judges are selected in Israel by a committee. It's called the Judges Appointment Committee, and they serve until they reach the age of 70, which I always said, why 70? It was stated in the 50s when life was different. And okay, now I don't see this 70 anymore, but still, that's the number. This appointment committee represents the concept of combination of powers, a notion, if you wish, of the checks and balances, because it comprises 9 members and all branches of government are there. We have 3 judges of the Supreme Court, 2 representatives of the Israeli bar, which is, of course, the professional idea, 2 and 4 politicians, 2 members of government and 2 members of the Knesset. And it means that it actually represents all 3 branches, and a candidate for the Supreme Court must be selected by the majority of 7 out of 9, which means for me that each branch has a veto over the selection of a judge for the Supreme Court, meaning that it is not a political selection. And the politicians cannot decide who would be a judge of the Supreme Court, but the judges of the Supreme Court cannot decide either. They need to reach a compromise, an agreement. And I think it's a very good idea for Israel, the idea of compromise and agreement. Now, Critics have mainly argued that Israel judges are not representative enough, and I think is something that should be taken into consideration. And it is not really independent in a way that the institutional independence is problematic, because the judiciary is not administratively autonomous. It is a unit in the Ministry of Justice. I think that I will leave the question of the override, perhaps if you are interested later, but I would like to conclude with what is going on nowadays in Israel. I agree with the starting, I think, words that we hear here, that these are indeed, like I think Daniel Reisner said, that these are difficult times for Israel democracy, really difficult times. The government elected has proposed a judicial reform comprising 5 issues. I will talk about only about 3 of them. They would like to pass an override clause, meaning that a simple majority in the Knesset, 61, would be able to pass legislation which has been declared unconstitutional by the court, meaning that if the court says that a law infringes upon my right, and therefore this law is declared unconstitutional, the Knesset would be able to pass it again by a simple majority of 61, meaning absolute power. 2, the Supreme Court will not be able to deal with amendments to the basic laws. Now, it is very it's problematic, because in Israel you can take a law dealing with, let's say, the basic law Stephen Greenblatt, or basic law Claudia. Okay, there's no problem to enact, personal basic laws. In order to enact a basic law, you need exactly the same procedure and exactly the same number of members of the Knesset. 2 versus 1 may enact a basic law, no problem, and also make it amend it. So the Supreme Court will not be able to deal with amendments to the basic law, and of course, politicians will appoint the judges. And what these proposals have in common is that our government wants absolute power, unlimited power, to eliminate all restrictions on the legislature. And when we asked this government and some of the ministers, what kind of limit you will have on your power? What kind of protection will I have on my rights and freedoms if you pass this reform? The answer I got was, you can count on us. And frankly, I do not want my human rights to depend on any goodwill any goodwill of the government, not this government and not the next one. Human rights are not to be left to the goodwill of the governors. And the second thing that these proposals have in common is that almost every institution in Israel, which is currently professional, neutral, objective, and independent, would be politicized. The judges will be chosen by politicians, political control on the courts, the legal advisors of the government will be appointed by the ministers. And if this is not enough for you, let me tell you one more thing about the procedure in which this reform is being passed, which is for me incredible. We are witnessing sessions in the Knesset committee of a sort never seen before in Israel. Hasty, even brutal, sometimes humiliating, an ongoing contempt and disrespect towards civil servants and profession, to the point that it seems to me that the race to the finish line, meaning the rapid passage of this reform, justifies all means. And I will end again with Daniel Reisner's first words. These are indeed difficult times for Israel's democracy. And this is also something that you, should take into your account and mind. Thank you.
Thank you. Thank you all. It's a very good presentations. I don't know if Abner is still on. I think he may have had to get off. I don't see him. Abner,
No,
is Abner still with us?
Abner is here, yes.
Okay.
Hey, Steve.
So let me-
I'm going to take over for a Q&A, okay?
Okay, you take over. but I wanted to ask a question before you take over. And that is, I wanted to ask the participants, is it not a central problem, or putting it differently, is the fact that Israel does not have a bicameral legislation, Congress, Knesset, let's put it that way, a bicameral Knesset, because there's really a collapse between the executive branch, so-called, and the Knesset. They're one and the same. So you don't have, in both Argentina and the United States, we have 3 branches of government. In Israel, you really only have two branches of government, if I understand it correctly. And do we think that that's part of the problem, if we agree there is a problem there? The fact that there is no bicameral legislature and a separate executive branch. And anyway, I'll leave it at that. But I do think that that's part of the problem, structural problem in Israel. So you really have this one branch versus the judiciary, not 2 versus the judiciary. Let's put it that way. And there's also no regional elections in Israel, right? It's just the national elections and so forth. So both for the legislature and the executive, that you might call the executive, which is really part of the legislature. So anyway, I'll just stop there. Susie, yes.
I have a question, actually. It's clear. Do you want me to answer that? or may I ask a question? I would like to ask Claudia something that was very interesting.
Isn't that at the root of a lot of the problems that Israel is facing right now?
Okay, I think the main problem is that we do not have a rigid constitution, which we should have. And each day that passes by makes it more difficult to enact. I would actually entrench all basic laws now and, write down a new basic law on human rights and just, stabilize the rules of the game. Because we were like this also 50 years ago, but Israel was completely different then. We were, I think, influenced by the British model, that there are things that you do not do, it is not done, and then nobody would have thought of changing the rules of the game during the game. And for example, before electing a government, passing a basic law dealing with a 2-headed government, which we actually did a few years ago. Nowadays, I heard Abner saying that the American Constitution was amended 27 times since, I think, 1791. In Israel, 27 times amendments of the basic law. I think it's 2.5 years, okay? Not hundreds. Okay, this is, and that is a problem. We need to stabilize. I do not know about 2 houses of the Knesset, but I would take the system as
I didn't say 2 houses of the Knesset, but I said there's a collapse between your executive branch and your legislative branch. That they're all one branch.
Yeah, I just let me jump in on I'm not an expert on this, but I have a few thoughts on it, which are that I think I ultimately agree with what Susie's saying. That is, you can have a country that has a divided legislative and executive authority, like the US, in addition to the bicameral legislature.
Mm-hmm.
And legislation is difficult, meant to be difficult. You can have a parliamentary system where it's much easier to pass basic laws because you have the blending of the executive and the legislature. It's not clear to me, I'm sure people have studied this either normatively or empirically, whether one system or the other is more likely to both allow the society to progress and also to protect basic human rights. I mean, I think that in part depends, as Susie is suggesting, on the background constitutional norms and whether they're enforced properly. One other thing I want to say about the US system, which is that one of the things that many of you know has changed is over the last 100 years, is because of the enormous bureaucratic and administrative state that we have. Most laws are called regulations, and they're made by, you know, the Department of Commerce or the Federal Trade Commission or whatever, and they get a lot more stuff done than Congress gets done, which is now a big subject of debate by the more conservative justices on the court. So that's a little addition.
All right, well, let's, do we have some questions?
Do you have,
I would like to ask Claudia something that I've been thinking
Okay.
about when you talked. It's okay in English, Claudia?
Yes, of course.
Okay. You were talking about the decisions in Argentina to review the constitutional reform. Now, to review a constitutional reform is not a control de constitucionalidad de leyes. It's something else. It's reviewing the constitution. And what I wanted to ask you is, it means for me that Argentina has the doctrine of the unconstitutional constitutional amendments, meaning that you have the court that is allowed to review a constitutional reform?
No, well, that was a unique time when it happens. It is unusual to try to control if the new constitution or the amendment is okay, because the constitution is above any other law whatsoever. But what the Supreme Court did was not enter in the focus or the center of the decision to make a limit in the age of justices, but instead in controlling the due process. It is a procedural problem that it found. And as in many times in the Supreme Court history, it had controlled the proceedings of the National Congress. It seemed to be logical that it could do the same related to the Constitutional Convention. But luckily it happened only once, and after a democratic deliberation from law schools and the jurisprudence during 17 years, it came out this going back to saying that it was okay, and everyone made a deep breath of relief and happiness, because this is what at the moment the society was agreed upon.
Abner, you have your hand up, Abner.
Yeah, no, thank you. This is a really interesting issue that Susie is raising and Claudia is responding to. So a couple words about this. In the United States, even though the Supreme Court has a large power of judicial review, there is also a doctrine called the political question doctrine.
Right.
And the political question doctrine is somewhat amorphous, but there are cases when the Supreme Court decides, even though we could decide this case, there might be some law we could apply, it is better to leave it to the political process. And the constitutional amendment process is one of the areas where the Supreme Court has said, there may be complicated questions, but we need to leave it to the people and the states to work these things out on their own, which is sort of interesting.
Very interesting. It means
That's
that
a safety valve. It's a safety valve of sorts.
Sorry, Abner, by the way, in Argentina, we have the political questions doctrine, which is inspired by the American constitutional law. But in the recent years, there was a development towards a more open judicial review, sort of speaking. There is still an area untouchable, but it was reduced. So the power of the judiciary to control some decisions has slowly gone up. It's a bit hard to say the cases, but we have the same, but in the recent years, it evolved to a more higher control from the court.
I should add on that, because I know this is a group of lawyers and judges who may not know about this. One of the most controversial decisions by the Supreme Court in the last generation, certainly in the Roberts Court, the John Roberts Court, has been the decision in a case called Rucho, R-U-C-H-O versus Common Cause, if you want to look that up, to decide that political gerrymandering of legislative districts is a political question. I mean, we have the problems we have in the US, the deep democratic problems are each state gets 2 senators, the electoral college, which is crazy, the filibuster and the Senate, if you know about that, and the fact that local politicians can draw legislative districts to keep the incumbents in and keep the opponents out in very dramatic ways. And in a very important decision, 5-4, Roberts said these issues are beyond the ability of the courts to decide. They're left for the political process. Justice Elena Kagan wrote one of her most vigorous and sort of brilliant dissents. So that's ended up being a political question.
So each of these 3 systems or models has its weaknesses and its strengths. We can see that. Are there any other, do we have any questions?
Yes, so I'd like to, this is for Abner, and this is from I'm gonna say this wrong, I apologize, but Nomi from, I believe, from Israel. Can you elaborate on the following? Removal of members of Congress, which is relevant to considerations of removal of Knesset members, especially in view of the recent pogrom in Havaram, the incompatibility clause and whether can be a consequence of, and is there any lesson to be learned from the impeachment of the US president in regards to the Israeli parliamentary system and the prime minister?
Wow, okay, so those are separate questions. The first one is about removal of members of Congress, other than by losing your next election. It really very little, if you have, I'll give you the reference if you want to look it up. It's United States Constitution, Article 1, Section 5, Clause 2, which reads, very short, each House and the Senate, may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3, expel a member. So to kick a member out of the Senate, 2/3 of the senators have to vote. Kick a member out of the House, 2/3 of the House have to vote. There have been some instance of this, but very rare. I think most after the Civil War. What was the next question? Sorry, there were 3, I think.
So then the incompatibility clause.
Yeah, I mean, all I can do is refer you to it again. It's Article 1, Section 6, Clause 2. And in that clause, there's 2 sentences. It's the second sentence of Article 1, Section 6, Clause 2. But what it means is that if you are a member of the federal legislature, the House or the Senate, you may not hold executive office in the federal government. That is meant to keep us from being a parliamentary system. And then there was a third question.
Sure, this is a bit more subjective. Is there any lesson to be learned from the impeachment of the US president?
So I don't know exactly how Israel would do it. You know, in the US, we have had presidents impeached by the House, which is a majority vote, but then not removed by the Senate, which requires a 2/3 vote. So the former corrupt guy, otherwise known as Donald Trump, was impeached twice and not removed. Bill Clinton was impeached for lying about what he did with Monica Lewinsky and not removed. And way back after the Civil War, Andrew Johnson was impeached and almost removed. It was 1 vote short of his being removed. So I don't know what the Israeli system would be for that.
Removing a justice?
No, for removing maybe the PM or a high, someone in Knesset. I don't know. What is the answer to that, Susie? How do you remove member of the Knesset?
Well, first of all, a member of the Knesset who has been convicted in a final verdict of a criminal offense, and the court said that the offense involves what we say moral turpitude, then the membership of the Knesset ceases in the day this verdict becomes final. This is the main, actually, possibility for in order to expel. There is a possibility to expel members of the Knesset. It has never been used. I am not certain that this section is constitutional, but the court says it was an amendment made to the basic law on the Knesset dealing with the members of the Arab parties, that the Knesset wanted the power in order to be able to send them away, to expulse them. They introduced a new section saying that if this member of the Knesset makes something that threatens Israel as a Jewish and democratic state or supports terrorism, then he may be expelled by a large majority of the Knesset. I think it's 90. But I think this is a very problematic clause. I am not sure. I think this is a clause that actually infringes upon the right to be elected, and it was not passed by the way procedural. We're talking about Claudia, was not passed the way it should have been passed. It should have been passed by a majority of 61. There were only 59. But when the Arab party, I think one Arab NGO went to the Supreme Court, the court said, okay, somebody has been expelled. Nobody yet. So come back later. So go home, and then you can come back when it becomes, actually actual. And they, I think, import the idea of the ripeness doctrine from the United States, which I think it's not suitable for Israel, but this is what the court said. And therefore, I do not know if this section would be used. It has talking about other members of it, meaning that if, for example, a member of the Knesset, which is also a minister, or let's say a prime minister, not in Israel, of course, in another country, that is convicted in a final verdict of a criminal offense, then he is, at the same moment, he ceases to be a member of the Knesset. That's the arrangement in Israel.
But didn't your Supreme Court just recently rule that certain individuals could not serve in the cabinet?
Yeah, yes, this is, of course, there is not certain individuals. There's one person, we will not talk about names, of course, but the court said that it is this member of the, he can be a member of the Knesset, but he cannot be a minister.
Right.
It's
Can't be a minister.
unreasonable because he has actually stated
But that's something I
unusual.
think, unusual, and something that couldn't happen in the United States. I think
I think it could not happen, from what I know, in any other country of the world.
Right.
But in democracies, there are things that you don't need a legal statement for that. There are things that are not done. You do not appoint a minister who has been convicted 3 times of 2 times. Okay, this is something that when you go to the court said, okay, there is a reason why he cannot be. Actually, we have a new proposal, a bill, saying that even if the court declared that this minister cannot be a minister, he will be a minister anyway. This is a new basic law that we are dealing with these days. It is, of course, this is not the real, wording of the law, but this is the meaning of this basic law. Obama used to say, yes, we can. In Israel legislation now, the legislature says exactly the same. Yes, we can. We can do that. We do not like this decision of the Supreme Court. Yes, we can.
I think Alyssa, there's a question from Gustavo Galante.
Yes. If everybody is okay with staying on a bit more, feel free, of course, to leave if you need to. Yes. Let me see if I can find him again and unmute him.
Okay.
Gustavo. 1 second. Gustavo, where did he go? Oh, he got kicked out. That's what happened.
No? Okay.
I'm sorry. Yeah, I think we're okay. I think we can probably, unless there are any more questions, I think we're probably ready to ready to close if people are okay with that. Our last call, if you want to raise your hand figuratively, feel free.
Thank you to
wanna-
Alyssa and Steve and everyone else.
Well, I want to thank all of you who have participated. I want to especially thank Alyssa for her work organizing this, as she has done so well, and also Hernan and Augustin, and thank you all. I think this has been useful. I think we've shown the contrasts and the differences between the systems. A lot of them are the same, but a lot of them, or numbers of them, are different, I think, in significant ways. So, and hopefully this will enlighten some concerns that people have about what's happening in Israel. So by looking at other systems.
Thank you. Thank you so much to our speakers, to Abner, to Claudia, to Susie, of course.
It was a pleasure.
Thank you. And we look forward to collaborating more with your group in the future. Thank you so much.
Working on some others, yes.
Thank you.
Absolutely.
Thank
Thank you,
all.
Elisa. Thank you.
See you.
Bye to all
Thank
of
you.
you.
Claudia,
Bye.
thank you very
Oh,
much.
and I do have
Bye.
a recording that I'll send around.
Was there a question? Okay, thank you all.
Bye-bye.
Bye-bye.
Thank you all. Bye-bye.
Bye.
Bye-bye.